What is going on, everyone? My name is Mark Real Jr., the Father's Rights Attorney, and you are listening to another episode of the Father's Rights Playbook. On today's episode, we have managing attorney here at Real Father's Rights, David Taub, and we're here to talk to you guys about, really, we'll say, an intersection between family law and dependency court, and that is 3027 investigations. David, how are we doing today?
We're doing great, Mark. Thanks for asking. Glad to be here.
Awesome. So I'll pass this off to you, David. So you're in there with a client in family court, and the judge starts talking about a family code section 3027 report or investigation being ordered. What is a 3027 investigation?
A 3027 investigation occurs when the court believes there's any cause to have both parents investigated for any sort of child abuse, any sort of danger to the child in the home itself, by the parent, by a third party within the home. The judge has a lot of leeway to say, we're stopping the regular family law case here. We're putting a pause on it. We're bringing in Child Protective Services to come in and investigate. Interview the parents, interview the child or the children, interview any third parties involved in the household to determine if this matter should remain in family court or if this needs to be shifted over to juvenile dependency court.
That's a big piece. That's kind of the intersection of dependency and family court. In 3027, it can be requested by one of the parties. Mom could make an allegation, hey, our child's being abused and is saying this to me. Dad could say, hey, mom is punishing the child inappropriately. Or you could have teachers, doctors, any number of mandatory reporters make a report that then ends up instigating this 3027 report in family court. So what happens in a 3027 investigation? Can you walk through the process of what someone could expect?
Well, you can expect to get a call from California Child Protective Services or the county that you're in. Their county Child Protective Services will contact you to interview you, and if the children are with you, they will interview the children separately. They could have cause at that point to refer it over to dependency court if they find there's an immediate need for what's called county services to step in. And those services, it sounds very nice. The services come in to rehabilitate or to bring the parent up to a standard where they believe the parent can, again, safely parent the child. Now, the reality is CPS will make the call during that investigation that if they have to, they will refer it over to dependency court, and your rights as a parent may be temporarily suspended, and your child may go into what they call the system, which could be foster care. It could be the other parent. It could be a grandparent having temporary custody.
We handle both the family court side of it and the dependency court side of it. When it moves to dependency court, essentially those are proceedings to strip one or both parents of their parental rights. For example, I had a case that it actually went to dependency twice. The first one was the daughter made allegations that the dad's aunt had inappropriately touched her, and the dad knew about it, and it got referred over to dependency but got kicked back to family court pretty quickly after the 3027 investigation and the initial hearing. And the second time was mom got arrested, actually got raided by local law enforcement on some criminal activity, and they found drug use occurring in the house. Our client's child was not there, actually was with dad, but that individual's other two kids were there, which created a referral immediately to dependency court, which drug our family court case now into dependency, because your family court case will stop in its tracks. The family court judge, if you get moved to dependency court, stops.
Everything freezes at that point.
Yeah.
If you have any other issues involving property or anything outside the children, court doesn't care. You're now in dependency court. They're going to put everything on hold.
The 3027, they're going to talk to the kids. They're going to talk to both parents. They're probably going to show up at both houses, and they're going to do a full investigation. It's not just going to be the issue. It's going to be everything. They're going to make sure that one or both parents have appropriate living situations. They're going to make sure there's no major issues with either parent. So your co-parent could get arrested for drug possession or something like that, which necessitates a referral to dependency court. CPS is still going to show up at your house, walk through your house, make sure you have food, appropriate accommodation. So you could have done nothing. You could have been a parent who had 50-50 custody and the other parent gets arrested for something. They're still going to complete a full investigation against you.
Right, and you just have to write it out. You have to do what they say. Rely on your lawyer if you do have a lawyer. And if it's us, we'll get you through it. We'll get you back to family court, certainly. It is an unenviable position for any parent to have a referral for 3027. You're also at the mercy of the speed of the CPS agent. These things can take months to complete.
Statutorily, they're supposed to take 30 days.
They can, but we do a lot of our practice in the Inland Empire and Riverside and San Bernardino counties. Also, I imagine it's the same in Los Angeles and Orange County as well. If it cannot be completed in 30 days, they will complete a report that simply states, we need more time, and they will get more time.
Yeah, they'll ask for 30 or 60 days more, and I have never seen a judge not say, all right, we'll be back in 30 days, we'll be back in 60 days for the return of the report, which can be unfortunate because there are situations where the allegations are so serious that one parent's parental rights have been completely suspended. So we get to the referral occurs, CPS is doing their investigation. Really, there are two outcomes when it comes to the allegations. They will hopefully say the allegations are unfounded, which basically means they did not have enough evidence to confirm.
Right.
Or they can substantiate the allegations, which basically means they have enough information to say these actions did occur, take appropriate response to said allegations.
That's where Welfare and Institutions Code 318 kicks in, which states that they can start the proceedings for the county to take jurisdiction of your children. They could decide that the other parent may be worthy of being the parent while you undergo county services to become eligible to be a parent again. Or they may decide that both parents are not in the clear. Again, they can consider a grandparent taking over, or they may put the child in the system.
Yeah, when you get moved over, when there's a substantiated finding, especially something of sexual abuse or not appropriate living conditions, understand you could be perfectly fine and you get drug in. Hopefully you're the one who gets drug into dependency court because the other parent has made an issue and you're not too much in question, because usually then the county will work with you to make sure you get the custody and everything happens appropriately. But it's one of those things. It's really, really scary when there's something substantiated. And I've even seen parents, you mentioned grandparent, like they realize neither of them is going to be found fit. So they go out, aunt, uncle, grandma, grandpa, whoever it may be, and get them to join into the dependency case. Because honestly, the worst thing that could happen with any situation is the kid end up in, the county finds that no one around them is fit and they end up in county custody.
Right. Right, and we need not get into detail on that except to say a horrible option for the minor child.
Never wish that upon a child, and it truly has to, for that to be the best option, it truly has to be a disgusting situation.
It is. Now, we do provide services for dependency court, and I will say this much. If a grandparent is chosen, eventually they'll be compelled to do a guardianship for the child, and we also do guardianships here at Real Fathers Rights.
Yeah, so I mean, that's one of those things, especially if the parents are still together and they get caught up in something together, a lot of times a grandparent is the best option in the short term to ensure that the child doesn't end up in county care. And the case I was talking about earlier, actually, the other two kids that were not the children of our client, grandma actually stepped in and got custody, and just through client found out that she actually did go through the process and is now the guardian of both of those children. So that wasn't necessarily a bad situation. I mean, realistically, you remove the mom, who was a rough situation, but grandma was very actively involved with all the kids.
Can I add one more thing? I do have a little silver lining here on the 3027. If you're accused of child abuse and you go through the process and there's no finding of any abuse, and if you have enough proof to show that mother or the father, the other side, falsified the accusation, you are due not only attorney's fees, but sanctions, and the court can consider that you take over custody of the child for the false allegation.
Yeah, I mean, it's one of those things, a situation by situation thing, but when those allegations occur, or I usually tell if it's usually the other parent and there's no concerns, no issues with our client, like when CPS shows up at your house to walk around, like give them the grand tour, like show them everything that's going on. They're not worried about the liquor cabinet. They want to make sure, does the kid have a bed? Do you have food in the fridge? Is the house clean?
I had a friend accused of not feeding their child, their 12-year-old child. CPS made a surprise visit. They can do that. And wouldn't you know, CPS showed up when the parent was making like a pot roast with the child at the kitchen table, and they invited the CPS agent to come and sit and eat with them. And just a wonderful stroke of luck there in the timing.
I will say it's a situation by situation basis, because when they show up at your house, they don't have a warrant, they don't have anything. You technically don't have to do anything with them.
Right.
So there could be situations where we would advise a client not to participate and not to allow any of that without the presence of a warrant, and the likelihood of, unless they think a kid's actually in danger of CPS getting a warrant, pretty low. But if you got nothing to hide, there's an opportunity to get, especially if you're in contested custody hearing, if you don't have anything to hide, and especially if you're not the one really actually being investigated, to get CPS to sign off on you have appropriate accommodations, the fridge was full, all of a sudden you have the most authoritative story in all of this. Is like, if they go and argue he doesn't have food, he doesn't have somewhere to be, like, well, we investigated by CPS and they thumbs up everything.
That's right.
Yeah. So not an enviable situation, end up in a 30-27, but a lot of times you can navigate through and end up with positive outcomes. Well, David, thank you so much for your time today and your insights. To all of our listeners and viewers, thank you again. I hope you found this informational, educational. Hopefully David was a little bit entertaining, because I know I'm not. And we'll see you guys next time on another episode of the Father's Rights Playbook.
Y'all be good to yourself.